And it would have to be established that Article 12 doesn't apply, and that's why I'm resting on Article 12 and asking for eternal.
The errors, potential errors, are in his application of the defence under Article 13b, and I think sufficient time should be set aside to deal with that issue, if I may say so.
My position on that would be that the decision on 13b is a question of fact, and we have standing principles on that. This decision on discretion is
well, he potentially was, sorry.
Well, yeah. We have in mind, just to flag it up for you, the points raised by the second respondent in paragraphs 33, 39 and 40, perhaps especially the first sentence of paragraph 39. Yep.
And also, may I add into that, this is an inquisitorial system as well, partly adversarial, partly inquisitorial. And, sorry?
The in-house would not normally act to an out-house judge, so they would normally decide matters themselves if they thought the out-house judge had gone wrong.
So, the point I wanted to emphasise is everybody's very excited about the big point, but that may actually not be even the most difficult point in the case. So allow plenty of time for these other matters.
So it's 39, I've got it. Shall I proceed with Rien?
Yeah.
Thank you. This is in a bundle at page 519. And the case deals with the controversy over whether there is a discretion to return a settled child. What had happened here were there were two children who had been brought into the UK from Zimbabwe, initially wanted to go back, but had got on with their lives and had become settled. And by the time the matter reached the courts, they objected to return to Zimbabwe. It was not a grave risk of harm or intolerability case at all, but it examines the range of international views about discretion to return a settled child. And the court will have seen that Lord Roger dissented on the mechanism for this and thought that if there was a settled child, discretion lay outside the convention, and the other members of the House thought that discretion lay within the convention. So that was the controversy which was actually we're looking at. And the court will see that just briefly. I'm not going to read it out. From the first point in the rubric, and from what Lord Roger says, paragraph 7 on page 528 of the bundle. Now, Baroness Hale, with whom the other members agree, gives the leading speech, and I'm going to dive into that, if I may, at paragraph 20 on page 531. So she starts looking at settlement and discretion, and from paragraph 20 onwards, she reviews the various views on discretion, and she comes to sum it up at paragraph 29 on 535, when she says there's a choice between a number of options. But it's paragraph 29 that she starts on that. So she says, in theory at least, there are three solutions. One, once any ground of opposition has been made out so that there is no duty to return the child, the court must consider whether to use other powers outside the convention to return the child. Or two, the Article 13 and 20 grounds being permissive only contain within them a discretion nevertheless to return the child, but the Article 12 ground not being so limited does not. Or three, all the grounds contain within them a discretion to return nonetheless. And she comes down in favour of three. So that's taking matters very short as to what's at issue in this case. But she goes on to say, of course, cases all vary. one size does not fit all. And that you can see from the foot of probably from 31 onwards. Paragraph 39 is the one size fit does not fit all quote.
Sorry, which paragraph?
39. There is always a choice to be made between summary return and further investigation. There is also a choice to be made as to the depth into which the judge will go in investigating the merits of the case before making the choice. One size does not fit all. The judge may well find it convenient to start from the proposition that it's likely to be better for a child to return to his home country for any disputes about his future to be decided there. The case against his doing so has to be made. But the weight to be given to that factor and to all other relevant factors, some of which are canvassed in the J case, will vary enormously from case to case. And then she continues through and examines that in paragraphs 42 to 44. And in summary, she says the weight to be given to convention considerations of return and the interests of the child will vary enormously. And that's in paragraphs 43 and 44. And then at 45, we pick up the thoughts from In Re D, where she says, by way of illustration only, as this House pointed out in Re D, a child, it is inconceivable that a court that treats the conclusion that there was a grave risk of exposing to physical or psychological harm, otherwise placed in an intolerable situation. It was not the policy of the Convention that children should be put at serious risk of harm or placed in intolerable situations. And she continues in paragraph 46, taking matters about 5 lines down, letter D. These days, and especially in the light of Article 12 of the United Nations Convention on the Rights of the Child, courts increasingly consider it appropriate to take account of a child's views. Taking account does not mean those views are always determinative or even presumptively so. Once the discretion comes into play, the court may have to consider the nature and strength of the child's objections, the extent to which they are authentically her own or the product of the influence of the abducting parent, the extent to which they coincide or at odds with other considerations which are relevant to her welfare, as well as the general convention considerations referred to earlier. The older the child, the greater the weight that her objections are likely to carry. That's what I can say a child's objection should be.
Can I ask you what might be regarded as a sort of idiot boy question? But why would it ever be in doubt that you would have regard to the child's views if the child is of is the underlying? I mean, I think about common law. And in common law, obviously, a court listens to what a person has to say, where it's going to be affected by the court's decision. I mean, for example, a plea in mitigation in a criminal trial. Now, I can see it's different if you have a child, which a common law would be different if a child is so young that it would not have been regarded as capable of expressing a view. But if you're talking about a child, say, of 14, what even a common law, would there have been any doubt about a child's views being taken into account?
Well, no. And Perez-Vera makes the point in the report. We have now the point in Article 12 of the UNCRC.
Yeah, I'm wondering, do we need any of this? Is there a common law duty anyway?
The difficulty is that the Inner House has said it, and I am here now to say, well, this was just wrong. It stands out. That first sentence of paragraph 55 stands out, and one thinks, good gracious, why? It just doesn't seem right.
Well, the only reason is some confusion is generated by virtue of the fact that these are proceedings as between two different people. Not the child isn't actually part of the petition, but that's absolutely no reason at all why the child who is the object of the proceedings shouldn't be able to express views.
This child
always subject to the best interests of the child, which is also another element of the Hague Convention.
This child is a party.
This child is a party.
It may be that the in-house thought-taking account did mean that the view would be determinative. But for so long as you say the view is not determinative or even presumptively so, I speaking for myself, I can't see any reason why you would reach a conclusion.
No, and the inner house was taken to these authorities. So I was not present in the inner house. But of course, if we're going to Article 12 of the UNCRC, the guidance from the UN Committee says that even very young pre-verbal children can express views in other ways.
Yeah.
The common law feeds into the Strasbourg jurisprudence that there is a procedural obligation to have a fair system.
Yes.
So
it all speaks together.
It all speaks together, but and indeed, I mean, there was potentially a slight difficulty relying upon the United Nations Convention on the Rights of the Child because it wasn't in existence at the time that the Hague Convention was signed and ratified by the United Kingdom. But all the same, one doesn't have to go there. One doesn't have to go to the United Nations Convention on the Rights of the Child. It informs. It's informative of the obligation at common law. But one has to be a little bit careful about the parameters, because we're talking about the Hague Convention, and you potentially, if you think in terms of divorce proceedings, would there be a similar obligation there?
Absolutely.
Yeah. So a statement of arrangement for the child must be given the opportunity of expressing views about that.
Indeed.
And does that occur in Scotland?
Absolutely. Much to my cost, as I lost the case quite early on at that point.
Right, okay.
So, yes, it was actually written
and then in mediation, in mediation between parents.
Well, there's an issue there, but going back to my Lord's first point, our Children's Scotland Act was passed in 1995, and Section 11.7 of that Act expressly was drafted in the light of the UN Convention on Article 12. And there's a case called S against S, where that was sustained in the inner house and explored in the inner house. So we are wholly accustomed and have been accustomed for the last 30 years to have children's views taken into account before we make any order. The only thing that's happening at the moment is we're looking at children younger and younger because we've, instead of looking at a cut-off age at 12, we're now more persuaded that a younger child may be capable.
The reference you just gave us was the Children's Scotland Act of 1995, section
11.7a.
Thank you very much.
And the case was S against S. I can find the court. It's Lord Mark in the chair. I think it was in the year 2000. I'll find the reference. And of course, what Baroness Hell goes on to talk about in M, just before I move on, is a child-centric approach. And I'm very conscious that Lord Doherty, in the case that he decided under the Hague Convention, which isn't in the bundle, but was H petitioner, was attracted by the child-centric approach to these matters. And if I might then take up the discussion with Lord Reid, what Baroness Hale does in the E case is to reinforce that the Hague Convention is consistent with the UN Convention and with ECHR. Now, the E case is another case where the court was actually dealing with a problem that wasn't directly involved in the case. The issue there was Neulinger and what had happened in Neulinger and to what extent one departed from a summary examination of the facts to an in-depth examination as was advocated by the Supreme Court, by the Strasbourg Court in Neulinger. And the reference in Neulinger is paragraph 139. I'll just give the court the reference. It's the bundle 820. The E case starts on page 496. And one can see from the outset, bundle page 502, that the court is launching in with a concern about the consistency between the Hague and the DCHR based upon what was said in Neulinger. I'm assuming I don't need to go into Neulinger, it's so often cited. But this actual case was an Article 13b case relating to domestic abuse. And just running quickly through this case, what Baroness Hill says at paragraph 14, bundle 506.
Sorry, para.
14. Is the best interest of the child at the forefront? Primary consideration of the Hague Convention, just as they are in terms of UNCRC. There's an assumption built in at paragraph 15 that the child's interest is going to be served by a prompt return. A reference back to INRE D. And an emphasis on the views of the child, which comes in from paragraph 16, including giving the child the opportunity to be heard at paragraph 17. And the confirmation that we're consistent with Strasbourg jurisdiction prima musa, because a national court doesn't order return automatically and mechanically, it does examine the particular circumstances. And that is at paragraphs 72 and 75 of INRE D. Now, if I can jump over that fairly rapidly, because I'm conscious of needing to keep the time. And take the court to paragraph 32 on page 512. When it said that the words of Article 13 are plain and need no further elaboration or gloss, it's clear the burden of proof lies with the person, institution or body which opposes the child's return. Second, the risk is at 33, the risk to the child must be grave. It's not enough, as in other contexts such as asylum, the risk be real. It must have reached such a level of seriousness as to be characterised as grave. Although grave characterises the risk rather than the harm, there is in ordinary language a linkage between the two. Thus, a relatively low risk of death or really serious injury might properly be qualified as grave, while a higher level of risk might be required for other less serious forms of harm. So there's an inverse relationship between the nature of the harm and the level of the risk. In one of our cases, Lady Wise characterised this as a slide rule approach in AD against SD. But she goes on at paragraph 34. The words physical or psychological harm are not qualified. They do gain colour from the alternative or otherwise placed in an intolerable situation. As was said in UD, intolerable is a strong word. When applied to a child, must mean a situation which this particular child, in these particular circumstances, should not be expected to tolerate. Those words were carefully considered and can be applied just as sensibly to physical or psychological harm as to any other situation. Every child has to put up with a certain amount of rough and tumble, discomfort and distress. It's part of growing up, but there are some things which it's not reasonable to expect a child to tolerate. Among these, of course, are physical or psychological abuse or neglect of the child herself. Among these also, we now understand from exposure to the harmful effects of seeing and hearing the physical or psychological abuse of her own parents. So what I take from this, and I lay emphasis on it again, is that the opposer to return bears the burden of proof. The risk must be grave, not just real. There's this inverse relationship between harm and risk. There are two separate defences in 13b, either grave risk of physical or psychological harm or grave risk of intolerable situation. They're separate. And in fact, if we come in a moment to look at some of the internalisation of the Convention into domestic legislation in places such as New Zealand, they are actually in separate clauses. And intolerable is a strong word. And then the court goes on to think about the issue of domestic abuse, which is not at issue here. The law ordinary did not find that it's domestic abuse. I'm going to refer just briefly to say that there was a postscript in the slightly later case of Re S, which talked about Neulinger, but I'm not going to, I think time forbids me to really go there. So from thus far, the message from this analysis is the only case that's almost in point is Re E, where the context is domestic abuse. And as we've already discussed, there is no authority for the proposition the court is regarded to disregard what a mature child has said in reaching a decision on exception to return. And the court must examine the particular circumstances of the particular child. And of course that is consistent with the case which the court has pointed out in Strasbourg, the MP against Greece case. That was a case which learned friends for the child had already had translated, so the court has the benefit of translation. So that takes me to my second proposition, and that is that the Inner House erred in holding that the discretion of the court was fettered. Now, I'm spending less time on this, partly because I've covered it in the earlier examination of the three principal cases, but also we are all agreed that there is a discretion to exercise. And that I'm adopting my case, or our case, and our case sets this out at paragraphs 23 to 32. If I can mention briefly the Supreme Court, US Supreme Court case of Golan against Sada, where Justice Sotomayor really gave very short shrift to the proposition that there was any particular requirement imposed by the Convention on the exercise of discretion. That case, and I'll just give the references for sake of speed, starts on the bundle at 857, and the points are made by Justice Sotomayor at 848 and 849 to 50.
Sorry, 848
and 849 to 50.
And that was a unanimous court?
Yeah, no, it wasn't. It was a 6-3 as a...
Oh, it says delivers the opinion for a unanimous court.
Oh, sorry. In that case, yes. Apologies. So nothing in the Convention's text either forbids or requires consideration of amelioration methods in exercising discretion. And they're quite scathing about the thought that that was imported into the test. But that brings me to the one case which is directly in point here, which is the New Zealand case of S against S. And I acknowledge the assiduity of my learned junior, who looked through 428 incadet cases and over 200 domestic cases and found one directly in point. So I'm bound to acknowledge Mr. Fitzgerald. So page 856.
Sorry, 8.
5-6, that's where the case starts. What this case was about was a mother who brought 3 children, aged 11, 13 and 15, from Australia to New Zealand. And these children wanted to go home to Australia. And the judge at first instance, who was District Judge Orbin, Family Judge Orbin, decided that returning them was intolerable. And in doing so, he gave very little consideration to the children's views. That was appealed to Mr. Justice Fisher. Now, this case is interesting because it reached a tertiary level. It was appealed to Fisher, and then it was appealed on to New Zealand Appeal Court, which was the ultimate court other than the Privy Council. But if one goes to the bundle at page 864, Mr. Justice Fisher, in dealing with District Judge Orbin, says this, 10. The other legal question this case raised was the way in which the court should treat a mature child's wish to return. The effect of 13.1d is the court has the power to give effect to a mature child's objection to return. There is no express articulation of the converse. Should the court be influenced by a mature child's wish to return in circumstances where it might otherwise have been inclined to allow the child to remain? The answer seems to be yes, for the following reasons. First, the contrast between the express statutory reference to a wish to remain and silence on the corresponding question of wish to return is not surprising given the scheme in sections 12 and 13. He's referring to the translation of the Convention into the New Zealand legislation, so it's Article 12, Article 13. Once the threshold requirements of 12 have been satisfied, return will presumptively follow in any event. The sole purpose of 13 is to single out exceptions to that presumption. One is the mature child's wish to remain, but the drafter could well have thought it redundant to express the articulate additional reasons for supporting a presumption which is already there in Article 12. Second, there is a significance expressly afforded to the child's wishes in 13.1d itself. It's difficult to see why more weight should be given to a mature child's wish to remain, the same child's wish to return. Either a mature child wishes are to be respected under the Hague Convention applications or are not. Thirdly, the framers of the Hague Convention assumed that a mature child's wishes would be taken into account without distinction between a wish to remain and a wish to return. The background to the Convention is outlined in the explanatory report on the Convention published by the Permanent Bureau of the Conference in 1982. The report was prepared by Professor Eliza Perez-Vera. She has been reported to the Hague Conference on Private International Law where the Convention was prepared. In Delabark against Christie, it's a New Zealand case, the Court of Appeal relied on it as a guide to the ideas and principles and so on. As to the wishes of the child, the report said this, the Perez-Vera report said this at paragraph 30. In addition, the Convention also provides that the child's views concerning the essential question of its return or retention may be conclusive, provided it has, according to the competent authorities, attained an age and degree of maturity sufficient for its views to be taken into account. In this way, the Convention gives children the possibility of interpreting their own interests.
That is slightly different from obviously a child's wish to return should be taken into account, but the weight to be attached to the child's views as to whether he would suffer extreme psychological harm if his mother committed suicide is a totally different question. And I wonder whereabouts in this judgment is that issue raised and considered?
The reason that I'm dealing with it this way is because Mr. Justice Fisher is dealing with the exercise of discretion. The district judge, Judge Orbin, found that there was intolerability. So he found the prima facie exception to return established.
And what was the degree of intolerability in this case? What was were the intolerable circumstances? Was it of extreme psychological harm?
No, it was the mother wasn't going to go back with them, and there were various allegations made in relation to the mother, which... well,
the mother not going back with them is in some respects... well, that's slightly different in scale than...
Mr. Justice Fisher took it that the intolerability... He wasn't going to interfere with intolerability as established by an experienced family judge. Yeah,
well, in our case, if you put it into our case, there are various factors. They were called the other factors by the Lord Ordinary. And you could well see that the child's views about the other factors are relevant. But what I have difficulty with at the moment is how the child's views, and indeed I have difficulty with seeing whether the judge actually addressed it, and whether the child actually addressed it, whether the child's views as to what the impact on him would be if his mother committed suicide. That is the essence of the Article 13b defence, combined with all the other holistic elements. But at the moment, I don't see the judge addressing that.
I'll come to the judge addressing it, because I say the judge did address it, and I say that this was a finding in fact, which is not disturbable by this House. And I say that the exercise of discretion is not to be disturbed on appeal, given that I say that the Inner House disturbed for the wrong reason. That's where I'm going to on this. I can go perhaps get a little further into Mr. Justice Fisher, because there's just a little more I want to say on this, and I can perhaps come back to why it is that the family judge found intolerability established. But I'm taking this on the basis Fisher's exercising discretion. He's not looking at the basic finding of intolerability. He refers on page 865 to the United Nations Convention and to the impetus that a mature child's wish to return has. That's paragraph number 20 on that page. And he summarises the legal principles which apply, and I don't think I need to repeat those, but I pay particular emphasis on paragraphs G, H and I on page 866 of the bundle.
Paragraph, line 22, he observes, of course, the matter of degree, the weight to be attached to the wish will turn upon all the surrounding circumstances, and that's the same in every case, really. It's a principle of our law too.
Yes, that's now absolutely accepted. And then he turns to the particular case in question. So, to answer Lord Stephen's question, there are some of the circumstances set out at paragraph 866. There are issues of domestic abuse, excessive control, physical abuse and so on, which are said to prevail.
And were there protective measures in relation to those? They're obviously inadequate, is that right? Not or?
Whatever it was, the issue was it was going to be intolerable.
So where are you reading from now?
I'm simply looking at the issues on page 866 from number 14 following, where Judge Fisher lists a number of considerations. And then at 867, it's not suggested this is one of the extreme situations in which a dangerous parent is poised to strike as soon as he can get his hands on the children, in which the children are liable to arrest in their country or a state of civil arrest or anything of drastic nature. The opposition to return rests on the contention the mother is incapable of taking an effective part in defended custody dispute. The custody will go to the father. In default, future access to the mother is likely to be inadequate, and father is an undesirable parent. Those are valid reasons for thinking that returning the children to Australia would expose them to the risk of physical or psychological harm. Whether this could be elevated to a grave risk and whether the risk includes a situation which might prove intolerable is more questionable. The general tenor of decisions in New Zealand and overseas tends to suggest otherwise. On the other hand, a broad value judgment has been exercised by an experienced family court judge after days of oral evidence. Sitting on appeal without those advantages, one should be slow to intervene. But I'm relieved of the need to determine the issue in isolation, because the decisive factor, to my mind, is the wishes of the children. I hope that goes some way towards answering Lord Stephen's question. And then he identifies it for the critical error of principle. And this is at 10. In my view, it was at this point that a critical error of principle occurred. The children's wishes were devalued in two ways. One was the contrast with custody and access proceedings. Rather than clearly important in that context, it was thought really in these proceedings they may have some relevance. The other was the unfavourable contrast with objections to returning. Only in the latter situation might they be determinative. It is a reasonable inference that as a matter of principle the judge thought that little, if any, significance should be attached to their wishes. That gains strength, and in subsequent comment I come to the view that there is a grave risk that return of the children might well expose them to physical or psychological harm.
I'm sorry, what's the principle that you're just reading? What's the legal principle you're taking from this?
I'm taking the principle that notwithstanding the finding of an intolerable situation, there is still a discretion to be exercised in which the children's views have significant weight. And I'm reading from it just to show that the way that Miss Justice Fisher, in the only other case, now just case, dealt with those views.
I have no difficulty with the proposition that there is a separate discretion to be exercised and the children's views should be taken into account in the exercise of that discretion. What I have great difficulty with is going back to Lord Brown's obiter comments, subsequently confirmed in later Supreme Court decisions, that it's very hard to see how you can exercise discretion if you are returning a child to a situation which he cannot tolerate.
Yes, which is why there is more to be placed in my case on the first position than the second. But I'll come to why Lord Braid said if I had had a discretion to exercise, I would have exercised it in favour.
Yeah, but he did that on the basis of discounting the risk of psychological harm on the basis of the child being aware of the mental fragility of his mother. Awareness of the mental fragility of a mother doesn't address the question as to whether the child will suffer extreme psychological harm in such circumstances.
He also does it, my lord, on the basis that this is a child of 14, now 15, who has 10 months of childhood left and has his own priorities. And I'll come to this in terms of the International Centre's intervention paper. This is a child with his own personhood, with his own identity, who has to...
I've got no difficulty with any of that at all. But what I'm raising is he doesn't address the question, namely, what impact does the child's views have? And what did the child actually say about the risk of serious, extreme psychological harm to him in circumstances where the risk eventuates?
I think I'm better to leave that question, she says, ducking out,
right.
to Miss Shewan, because she represents the child, and I don't want to put answers in a child's mouth.
Yes, that's perfectly fair.
But is your, sorry, just returning to the point I think you were making, you're making the point that even if there's a finding of an intolerable situation, there's still a discretion to be exercised by the court. And is your point that the Inner House said effectively, I think you're saying, there was no discretion or somehow they were fettered, was the words you were using. But looking at paragraph 55 on page 86, my reading of what the Inner House said is really along the lines of what Lord Brown was saying in the case that Lord Stevens was just mentioning. Once you've got a situation that is intolerable, how would you exercise your discretion to return the child to that intolerable situation where there was that grave risk, rather than not exercising a discretion or fettering its discretion? I think that's the point I'd invite you to address.
And my answer to that is that you have to look at all the circumstances. You have to look at the mature child who is capable of being his own actor, own self-determiner, if you like. As Perez Vera acknowledged, this is a child who only has a year then, now less than a year of childhood left, who has his own priorities, has his own identities, and the case did not stack up before Lord Braid to saying that that was going to cause him intolerable harm. And that was Lord Braid's decision. He was the finder of fact. He was the exerciser of discretion.
But you'd agree that if he left out a critical factor, a materially relevant factor, that would undermine his decision?
My submission is he hasn't.
No, I know that is. Yes. But would you agree that if he did, that would vitiate his decision?
Well, of course, that's a strike proposition of law. It's difficult, isn't it? Because if one looks at what's happening in this New Zealand case, where Fisher's saying they never wanted to be here in the first place and they want to go back to their lives in New Zealand, the court's now faced with a young gentleman here who thought he'd come on a 3-week holiday to Scotland, never wanted to be in Scotland, and wants to go.
He was unlawfully retained in Scotland.
Yeah.
I mean, that's clear. So,
Yes, but it's more than that. It's more than that. Because if
and he
you
wants to
think of
return
it
to the USA.
Yeah, and if you think of it in terms of the International Centre's intervention paper, there's a whole issue of identity here. So let's take it, this particular young gentleman. He says, I'm an American teenager. I'm a growing personality. Where do I derive my identity? Where do I derive my self-esteem? Well, I play American football. I play centre. That's a crucial role to play in American football. I want to go back to my life and be who I am. I cannot be who I am in Scotland. And if my mother's standing in the way of that, then blow it. I want to go home.
If what gets in the way, sorry?
My mother's standing in the way of my personhood, my identity.
Well, she is raising a risk of extreme psychological harm to her son as the primary carer of her son. So standing in the way may not be a proper reflection of what the mother is doing.
This boy hasn't lived with his mother for the best part of a year. He lives with his father.
The Lord Ordinary found that she was a primary carer.
Had been the primary carer.
Yeah. And he hasn't been living with his mother, potentially in breach of a court order in Scotland.
Yes, but of course there was a standoff on that in Peterhead Sheriff Court, which I think is explained in the proceedings. That there was going to be, and there couldn't be an application to the court because of Article 16 of the Hague Convention prevented the court making any orders. So we've been in stalemate since last August.
I was just joining slight issue with the language of standing in the way of, and asking you to reflect on that.
Understood my position. I accept the reproof. The only thing then to refer to finish off with my New Zealand case, is that permission to appeal was refused by the New Zealand Court of Appeal. There was one decision given by Mr. Justice Keith. And
how does that help us?
With Justice Sustains Fisher. Refuses the appeal. It is the only case that is of any similarity or analogy in the whole of the bundle of hundreds of cases.
There is still a discretion. It can still be exercised. In the exercise of that discretion, you take into account, for instance, the aim of the Hague Convention, which is to return the child as quickly as possible, amongst a whole series of other things.
So one of the points that's made by the Court of Appeal is to say that there's a strong argument that the family court effectively denied itself discretion. And that was one of the points I wanted to take from what Mr. Justice Keith had said, and say that's effectively what I say the Inner House has done. Of course, that was 1999, and we were arguing for the significance of the children's views in 1999, and I do respectfully adopt the analysis of Mr. Justice Fisher and sustain.
And I do think you have to deal with the last two lines of paragraph 55. I mean, it's all very well pointing to what the judge said in SS, but we're in a different case where the judge has said a different thing.
Like something. There are just a few points possibly to make. No, perhaps I'll jump over them. I've set out in my case the issues in relation to increasingly appropriate to listen to children. We've discussed the issues in relation to children being afforded the opportunity to be heard, explored an MP against Keith. I've explored in paragraphs 38 to 49 of my case, under the heading of the UNCRC, what I say about listening to children. I respectfully invite the court to look at the intervention by the International Centre of Family Law Policy and Practice, and particularly to the issues of identity. The only point that I would make in relation to that paper is that I'm not in a position, from the perspective of a Scottish advocate, to deal with Gaelic, because we don't actually use the term or a concept of Gaelic competence in Scotland. We actually have a statutory provision, which I put in my case, the 1991 Age of Legal Capacity Scotland Act. And that test of competence capacity applies both in relation to participation in legal proceedings through understanding of what it means to instruct a solicitor, and in relation to consent to medical procedures and treatments through having a medical practitioner forming the opinion that the child has the capacity to understand the nature and possible consequences of the procedure or treatment. So I think subject to that qualification, I do commend the intervention from the International Centre. And then I come to a point which I'm conscious is troubling the court, which is the law of ordinary. And his opinion starts at the bundle on page 88.
I'm sorry?
It starts the bundle on page 88.
Right. 68.
88.
Oh, 88.
88.
Sorry.
And it's a matter of agreement between counsel in the statement of facts and issues at paragraph 7. There's no finding that H has been manipulated. He had solicitors before the action commenced. They were instructed and have represented him throughout. So, looking at this opinion, the law of ordinary starts by identifying the issues. And paragraph 5, we see his identification. I don't think anybody takes issue with it. The principal issue in this case is whether the respondent has made out her defence. There's a secondary issue as to whether the boy's strong wish to return to Florida is relevant in assessment of the Article 13b, and if it's not, whether his wish is such that in the event the defence is established by the respondent, the court should nonetheless exercise its discretion to order his return. So the law of ordinary knows what it's about. He then sets out the propositions of law arising under 13b at paragraph 6. None of those are in dispute, as I understand the matter. From paragraph 7 onwards, he reviews the case law. At paragraph 13, he acknowledges the dicta which say that if an Article 13b case is found to be established, then it would be inconceivable that the court would return the child. That's at 13. So he's got the law right. He knows what he's doing.
And do you criticise what he says? However, no, it doesn't matter. Sorry, go on.
He's just saying what the court says, and of course that is what the court says. Yeah. And he's right in the sense that he acknowledges that it's not re-em, it's actually re-em citing re-do. So he's read it.
And he says it's difficult to envisage circumstances in which a court would return.
He knows that. Yeah. Yes, he does. Which makes the fact he actually does it all the more cogent in my submission, because he understands what he's doing. He deals with the UNCRC from paragraph 14 onwards, and sums up the position at paragraph 15. And then he gives us a very detailed account of the evidence. And for a proceeding which is a summary proceeding, this is a very extensive account of what he has before him in terms of affidavits and reports. I'm not proposing to go through it in detail. Safe to say he gave very careful consideration to the evidence, good and bad, for the respondent I represent, and some of it was bad. What I do draw attention to is the paragraphs dealing with Dr. Edwards' report. Now, Dr. Edward did not see these children at all. She was asked to prepare a general report, and this was pointed out to the law of ordinary. He deals with her report from paragraph 61 onwards.
Just before you get there, Can I just ask you a question about paragraph 45? It was a point you made when you introduced the case that there'd been no finding of manipulation.
No.
I mean, that is true, because there is no finding of manipulation in paragraph 45.
Correct.
Is it satisfactory for a judge to identify that, to some extent, there appears to be some evidence of manipulation, but then not resolve the question, or at least bring it into account in evaluating the evidence of the child?
Well, my response to that, I think, is at paragraph 71 on HB page 121, where he says, H's views have been clear from the outset and is articulated in the answers lodged on his behalf. He wishes to return to the US, and in particular he wishes to be educated there in the system in which he's familiar rather than in Scotland. There is no doubt he has capacity to express his views, and he has sufficient maturity and understanding to do so.
The question I'm making, you say the child's views in any case have to be taken into account, and I understand that.
Yes.
If there is some evidence that the views have been manipulated, how is the judge to take that into account? Does the judge have to say, unless it is proven to the balance of probabilities that there has been manipulation, I assume that there has not been? Or does the judge say, when evaluating the views expressed by a child, I have to take into account that there is, to some extent, evidence of manipulation?
Well, it's back to Lord Hopkins' dichotomy that the law is binary. It's either found or it's not found. It's in Ribby, the analysis that you either make a finding in fact or you don't, and if it's not established as a fact, you leave it out of account. So he didn't make a finding in fact, and therefore it's not relevant for these purposes. And with respect...
But you're quite deliberate. The curious thing is he deliberately does. Yeah. He acknowledges that the factors cited appear to lend some support to the respondent's position, but I leave this factor out of account in my final analysis. But if he's attaching weight to the child's views, doesn't the question whether those views reflect parental manipulation matter?
The problem for Judge Lord Ornery in these sorts of cases is there's always an allegation of parental manipulation. I don't think I've ever seen a Hague case when child's views have been asked to take into consideration where there isn't an allegation of parental manipulation.
There might be a bit more material in some cases than in others.
There might indeed, yes.
And he deliberately decides there's a factor, and he deliberately decides to leave it out of account.
He doesn't leave it out of account so much in relation to B, who's only 8. But then he's dealing with H, who's 14 rising 15. And it comes to a view that he has capacity to express.
I think you're urging us to treat as of very considerable weight, and I'll just use those words, H's expression of view.
Yeah.
But you're saying it's perfectly all right for the judge not to assess those views against the existence of evidence to some extent that they've been manipulated. And I'm just struggling at the moment. I see the difficulty a judge has in these cases because the evidence will often simply be not tested, or usually won't be tested. And it's a summary process, as you said. But yeah. I am struggling with the structure of how to deal with that situation.
I see, but of course, the judges dealing with Hague cases, this was heard in a day. And it has to be a summary process. And so the judge can only do his best on it, and this is all he's got. And it is for the opposer
Is it best to say, well, I can see that there's potential for that,
and I'm not finding
but I'm just not going to determine it?
I can't determine it.
Is it not a fairer reading of 45? What the judge is saying, well, I've seen the evidence of the respondents' witnesses. That lends some support to the position the respondents puts forward, but the petitioner and H themselves deny that. So there are two bodies of evidence there.
Yeah.
And he's simply saying, I can't resolve that, so I'm leaving that out of account.
Well, if he didn't, I don't think... Well, if you take into account the children's views, and that is a requirement to do so, where those views are expressed. What weight do you attach to those views if there is a risk of manipulation? Found risk of manipulation.
That is a matter for a Lord Ordinary to weigh. And one's weighing it in a summary process where if you don't establish something, it has to be discounted, both in terms of the way facts are found and in terms of the way these applications work. And here the court has a child at almost at the extreme edge of being returned. Once he's 16, if he doesn't return now, he'll go within 10 months.
Yeah, it has to be read together with paragraph 71 as well, where the Lord Ordinary has concluded H's view has been clear from the outset, as articulated. So that this isn't something that's been
I think
on the Lord Ordinary's, if I can finish, on the Lord Ordinary's findings, something that has been influenced during the time that H has been living with his father.
No, and indeed, the petition was served on H right at the outset because it was known that he'd already gone to see a solicitor to ask that solicitor questions, and it was agreed that he would be served, or the solicitor would be served on his behalf. I understand the court's concern, but my response is really as encapsulated by Lord Doherty, to whom I'm grateful. There is a passage at page 119, where the Lord Ordinary sums up what he's to make of Dr. Edwards. As regards whether there's a reliable, and bearing in mind she's given an entirely theoretical report because she hasn't seen the children. As regards whether there's a reliable body of
Which paragraph are you reading from now?
68, my lord. As regards whether there's a reliable body of knowledge or experience to underpin Dr. Edwards' views, the petitioner points out she did not cite a single source, but the discussion in her report was based entirely on her experience, nor had she met the children. In her own words, the report was conjectural. This, in my view, goes to weight rather than to admissibility. And so this is in part my answer to my Lord Stephen's concerns. The evidence before the court about psychological harm to these children was not strong. It was from a psychologist expressing general views, not particular views, and conjectural views about these children, which weakens that line of argument and allows the Lord Ordinary in my submission to do what he did.
I thought it was agreed by the counsel for the petitioner that the children would, if the mother committed suicide, it would be traumatic for both children and would cause them extreme psychological harm, as was accepted by the counsel for the petitioner. And the Lord Ordinary says we hardly need Dr. Edwards to tell us that.
Right. Yes, yes.
Yeah. And it was agreed, presumably.
I'm told by Mr. Critchley it was agreed.
Yeah. And so whether Dr. Edwards does or does not have expertise in that area or whether there are deficiencies in her report, that aspect is a finding of fact by the judge.
Yes. So if we get then to past paragraph 71, which we've looked at, the submissions are dealt with from paragraph 72 onwards. And the submission for the mother are basically that H's views are not relevant. The submissions for the petitioner and for H, quote, Lord Doherty's powerful child-centric considerations. Paragraph 75 and onwards, we have the court's decision. The Lord Ordinary decides that this is not a case of flight from domestic abuse. The allegations of domestic abuse are insufficient to have found any grave risk, and that's in paragraph 75. He deals with the difficulties over accommodation, education, healthcare, and says, well, they're not ideal, but they're not a grave risk. He comes to the points which concern this court, saying there are 4 further factors to add to the mix: separation of the children from the respondent if they return to the US without her, the risk to the children of harm caused by deterioration of the respondent's mental health, including but not limited to the risk of suicide, the relevance of both children's wish to be returned, and the risk posed by a separation of the brothers. So those are what the law ordinary comes down to as being issues of real concern. But what he says at the foot of this is that he finds that they are real, potentially, as opposed to grave. And this is at paragraph 82. It may be that none of these factors on its own gives rise to a grave as opposed to a real risk that children will suffer psychological harm.
You need to read 80 and 81, don't you?
You do. Yeah.
80 and 81 are the critical paragraphs.
Yes, of course, of course. I accept he refers in 81 to a very real risk of psychological harm.
No,
It's more than that.
First of all, he refers to extreme high psychological harm to the children, both of them, accepted by the counsel for the petitioner if the mother unfortunately committed suicide.
Yes.
He then says, well, the slide rule approach, even a small risk of such extreme harm may constitute a grave risk. He doesn't expressly resolve that.
He says it may, but he doesn't come to the view that it does.
He doesn't articulate how he addresses that issue. He then adds in another risk. So that's the risk of suicide in paragraph 80.
Yes.
Paragraph 81 is a risk that if they were in the USA and the mother remained, as she was going to remain in Scotland, there was a possibility that they would worry about it. And that, he says, that too gives rise to a very real risk of psychological harm to them.
Yes.
So there are two risks.
Yes.
One is of extreme psychological harm, and the other is a risk of psychological harm.
And the first one is extreme harm that may constitute a grave risk.
Yes, yeah. But then he says may, and he has to resolve that. Yeah. And the way that he resolves it in my submission in paragraph 82, it may be none of these factors on its own gives rise to a grave as opposed to a real risk that children will suffer psychological harm or be placed in an intolerable situation should they return to the US with the petitioner. However, all of the foregoing must be viewed collectively. Yeah. In addition, their impact must be considered in relation to each child separately. Yeah. Yeah. And I come to that and lay emphasis on that because, of course, the previous discussion has been in relation to both these children. One of them is only 8, and one of them is nearly an adult.
Well, so he's identified a risk of extreme psychological harm due to suicide. And he then takes into account, in paragraph 86, the views of H.
Yes.
And he says he is aware of the fragility of his mother's health and better able than B to take an informed view as to whether he would find it intolerable to be living on the other side of the Atlantic from her, in circumstances about which he is reasonably well informed. He addresses the risk he's identified in paragraph 81, but he does not address the risk of suicide and extreme harm. So when he's taking into account H's views, he doesn't address the risk of extreme psychological harm caused by the mother's suicide. And in any event, being aware of the fragility of your mother's health doesn't address the question, will there be harm to the child if the mother commits suicide? And that is the question, and it's not addressed. Being aware of the fragility of the mother's health doesn't answer that question at all.
My Lord, my response to the first part of my Lord's concerns is that the suicide is wrapped up with the mental health and that the law ordinary is perfectly entitled to look at those two together. They're aspects of the same matter. So when the law ordinary talks about this in relation to H in paragraph 86, my submission is we can take it that because he's aware of this, he's looking at both the suicide arising from mental health problems and the mental health issues itself. The fact he doesn't separate them out in terms, in my submission, doesn't undermine his decision or mean that he hasn't taken this into account.
He doesn't. The evidence from H is referred to at just get the actual page numbers. If you just give me a moment.
Is it
It's
148?
148, paragraph 26. And this is the evidence before the Lord Ordinary. And he says, if I went back to the USA and my mum's mental health declined, so she tried to take an overdose again, I would feel sad, but I don't think I would blame myself because I haven't asked her to stay in Scotland. So H does not address the question. That is, he doesn't contemplate his mother's suicide and what the impact on him would be. So H's views about his mother's suicide have not been articulated, and the judge hasn't addressed them in his judgment. He doesn't address the impact on him if she committed suicide. And the reason for not blaming himself is that he hasn't asked his mother to stay in Scotland. He doesn't engage with the Lord Ordinary's finding that it was reasonable for her to stay in Scotland. And he is equivocal. I don't think there's an equivocal statement. There's certainly no demonstration of sufficient understanding, not comprehensive understanding, but sufficient understanding on behalf of a child as to the impact on him on a lifelong basis if his mother committed suicide.
On the other hand, this is a child who is nearly an adult.
Well, you keep making that
yes,
point.
Yes, I do.
I mean, it doesn't really go anywhere. I mean, if he were an adult, we wouldn't be here.
No,
it's because he's not that it's not his decision. And the court has responsibility for making the decision, and it's under a duty to take that decision in his best interest.
Having regard to all the various factors, it's not, of course, a best interest decision. His interests are a primary consideration, but there's a convention here which requires his return. There's a boy who's here unwillingly who wants to go home. And if he has to stay here, what's effect is it going to be on him if he has to made to stay because his mother has mental health difficulties? And you could equally argue, and in fact, a number of us were in court less than a month ago arguing about the mental health of a boy made to remain, American boy made to remain in Scotland by his mother when he wants to go home.
Sorry, I missed that. Sorry, what was that? Sorry.
One could equally argue about the mental health of a teenager made to stay in Scotland by his mother when he wants to go home. And a number of us were arguing this in a different case a month ago. So it's not so straightforward. One cannot simply say there is a grave risk here if his mother commits suicide. There's so much else in this. And I go back to the point of whose responsibility is it to establish this? And if it's not established, then he goes home.
Well, it's only not established by virtue of the evidence of H, and that evidence doesn't even address the grave risk to him of, the real risk, and to him of severe psychological harm, extreme psychological harm if his mother commits suicide.
And that point is reinforced because at 83, the Lord Ordinary does find that the grave risk defence is made out in relation to B, whom he couldn't attach weight to the views expressed. So it's the view, it is that, and paragraph 26, those two lines, that's the limit of it, isn't it?
Yes, and
that's what tipped the balance here.
What I say about this is that you can see the Lord Ordinary's addressed it because he contrasts B with H.
Well, but he's addressed it without recognising that H may not be a reliable, may not be giving a reliable view about his own mental health, particularly as he isn't even addressing the real risk of something terrible that might eventuate in relation to his mum that he would have to live with for the rest of his life. He just hasn't addressed that.
I'm going to pass this to Mr.
Yes.
Well, before,
I think it's better. I'm not just being a coward here. But
just to finish it off so that everyone knows. If you go to paragraph 88 then of the judgment, he factors H views into the equation, along with all the other factors.
Yes.
Okay? And he decides that nor would there be a grave risk of psychological harm. And so at no stage, I repeat, at no stage has he done the side rule test at all. And in order to arrive at the conclusion that there is no grave risk of psychological harm, he's factored in H's views. And H doesn't express a view about that at all.
H just says, I'm aware of it, I still want to go home.
Aware of what?
I'm aware of the fragility of my mother's health, and we can take back into the suicide issue, and says, I still want to go home.
Yeah.
That's probably the height of it.
I'm sorry.
I think I have probably run my time.
Yes, you're certainly well past the 12 o'clock that you mentioned earlier.
So I am. So just to pull my position together, my position is that the decision on intolerability was a question of fact. Now, I know we've talked about it as subjectivity and objectivity, but I respectfully adopt the International Centre of Family Law and Policy.
How can it be a question of fact if it's about a risk that relates to future events?
It's in the same way as one deals with this in terms of adoption. One has the findings in fact, and then one looks at the risk. And I say that's his responsibility. He's done it. And the same in relation
to... It's an assessment of risk.
Yes. Yeah. He heard all the evidence. He saw it all. We're not in a position to do that.
It must be the nature of an evaluative judgment,
yeah.
Mustn't it be?
Indeed.
It's not,
Indeed.
Not
yes. And even more so, the exercise of discretion was a matter for the judge at first instance. And if we establish that the inner house were not entitled to do what they did, and my submission is it's fairly obvious that their decision at paragraph 55 was wrong, and the Lords now raise a different issue with me, my response to that is, well, the Lord Ordinary did the job, a bit like Mr. Justice Orban in New Zealand did the job. And his evaluative exercise is not to be disturbed, particularly in a summary process. And his discretion is not to be disturbed.
Could I detain you just for one short moment? And that is, we got very useful submissions from the interveners. At Reunite, for instance, have at paragraph 43, one of their submissions is that there should be no evidence gathering exercise to inform any such inquiry. And at the moment, I have difficulty with that, and I was wondering what your views are about it. That's paragraph 43, page 17 of Reunite.
Well, there has to be some evidence gathering, but on a summary basis.
Yeah.
And one goes back to Baroness Hale and Imre E. We don't go into an in-depth inquiry, which is, with respect, what my Lords might be tending towards. This is a summary process, tending towards returning the child, unless the exception is established and the discretion is exercised in a particular way.
Okay.
I think I should sit down.
Well, thank you very much, Mrs. Scott.
My lady, I adopt the written case which has been lodged for the second appellant. And I plan this morning to touch on 4 issues: Article 13B of the 1980 Convention, Article 12 of the UNCRC, briefly Article 8 of the European Convention on Human Rights, and finally the issue of discretion. And I do intend to address the written case for the respondent in the course of those submissions. So turning first to the Article 13b grave risk defence, the position for the second appellant in summary is that the views of a child require to be taken into account in assessing the issue of intolerability in the context of the grave risk defence, and the court then requires to assess what weight to give to those views. Mrs. Scott has already examined the authorities in some detail, and I'll limit the mention of that to highlighting the dicta of Baroness Hale in In Re E at paragraph 34, which is at page 513 of the bundle, where she sets out that intolerable is a strong word, but when applied to a child, must mean a situation in which this particular child, in these particular circumstances, should not be expected to tolerate. The position for the second appellant is that the Inner House, in finding that the views of the child are irrelevant to an Article 13b grave risk defence, have misinterpreted the words of Baroness Hale with no adequate reasoning provided. The submission for the second appellant is that in assessing the particular circumstances of the particular child, the views of that child must form part of his particular circumstances, and quite simply, his views must be relevant on that basis. As the Lord Ordinary said at paragraph 85 of his opinion, which is page 130 of the original bundle, the court must have regard to the views of the child in considering any petition under the Hague Convention, not simply where a stated defence is that the child objects, and nowhere does either the Hague Convention or the UNCRC state that regard must be had only to views which point in a particular direction. There is, I say, within the written case for the respondent a fundamental misapprehension as to the test for the establishment of grave risk in terms of Article 13b, and it's at paragraph 20 at page 32 of the original bundle, paragraph 20 of the written case for the respondent, which is repeated at paragraph 24. The point is made, and it's asserted, that once grave risk is established, the perception of the child on intolerability is not relevant. Now, in fact, the consideration of whether a return would place the child in an intolerable situation is what requires to be considered in order to determine whether the grave risk exception to return is established or not. The views of the child are a crucial and fundamental part of the exercise in considering whether it would be intolerable for this particular child to return or not, and whether the grave risk is established. The issue of intolerability is not somehow something to be considered after the threshold of grave risk is met, as is suggested in the submissions. At paragraph 20, the respondent puts forward an argument that the views of the child could not be operative where there's a grave risk of physical harm, and that intolerability can be equiparated to physical harm. I say that argument confuses the requirement of the court to take the views of the child and to consider them, with the requirement of the court then to consider what weight to give to those views. Where a child is being subjected to physical or sexual abuse, for example, and expresses a wish to return to that environment, the court will take the child's views, they will consider the child's views, but they are likely to attach no weight whatsoever to those views. But that doesn't remove the court's obligation in the first place to hear the child and to consider then what weight to attach to those views. and that is regardless of what the Article 13b defence relates to, whether it's physical, psychological abuse or intolerability. And as Baroness Hale states in Re D at the end of paragraph 58, and for purpose of notes, that's at page 488 of the bundle, hearing the child is, as already stated, not to be confused with giving effect to his views. And the second appellant's case is not that the Inner House was somehow bound to give effect to his views. His case is that the Inner House were bound to listen to his views, to consider them, and to give due weight to them, and they failed to do so. The Esto case for the respondent is set out from paragraph 27 of her written case onwards, and that is at page 34 of the bundle. The respondent adopts the position that if the Inner House erred in law, then the child's views should not be attributed such weight as to result in his return to the USA. The position for the second appellant is that if the Inner House is held to have erred in law, then the Lord Ordinary heard the evidence, heard the arguments at first instance, and was best placed to make the decision on these matters. The submissions from the respondent at paragraphs 28 onwards can be seen as submissions which seek to relitigate the case, and this court does not have the full material before it, which was available to the court of first instance. Neither would that be appropriate when the court is asked to make its decision on the basis of errors of law. If the Inner House is held by this court to have erred in law regarding ignoring the views of the child, then it follows that the Lord Ordinary did not err in law in taking account of the views of the child. He was a judge at first instance who considered the whole evidence, heard submissions. I see his decision was not plainly wrong and should stand. As Lord Wilson set out in Ries, which is at paragraph 35, and again for the notes is at page 556 of the bundle. The appeal court should not overturn the judgment of the trial court unless, whether by reference to the law or the evidence, it had not been open to him to make it. At paragraphs 33 to 43 of her written case, and that is at page 35 onwards of the bundle, the respondent criticises the original decision of the Lord Ordinary, and that's on the basis that his decision was made against a background where the evidence of tolerance of the child was inadequate, and on the basis that the Lord Ordinary failed to engage properly with the issue of influence and manipulation by the father. And it is important to say, as has been touched on by Mrs. Scott already, that the exercise to be carried out by the domestic court at first instance in Hague proceedings is not intended to be a wide-ranging and thorough assessment and investigation of the welfare of the child. The concept of the Hague Convention is that that process will be carried out elsewhere the decision is return or not. And that can be seen from the chain of authorities discussed by Mrs. Scott, which start with Mamuso, Neulinger, Inri E. It is clear from that run of authority that the domestic court at first instance is required to engage in the exercise of swift summary decision-making that Baroness Hale makes reference to in Inri E, not the full-blown examination of the child's future.
No, but obviously here the Lord Ordinary did have to decide whether the 13B test was met or not.
Yes, my lord.
And the point that's been troubling us is essentially that in paragraph 80, he accepts that there was a real risk of the mother committing suicide, and he accepts, as is obvious, that her doing so would have detrimental effects on the child. But that factor seems to drop out of consideration when he carries out his assessment under 13b.
Yes, my Lord, and in this case, the Lord Ordinary has in fact done quite a thorough job in a position where it was Hague Convention proceedings, which were decided within 1 day. He's produced a reasoned decision on the basis of evidence, which I say was more than adequate in the context of that swift summary decision making. But I will look in detail, my Lord, at the point your Lordship raises. Yeah. I do say that the affidavit evidence of the second appellant was not the only evidence available to the Lord Ordinary. He had all of the evidence, he had all the affidavits for all of the parties which are not available to...
But if there are particular matters that you think we should look at, we've looked at paragraph 26 particularly of the... Yes. And you need to draw them to our attention, even if just by giving us the page references. It's not enough just to say there was a lot of evidence.
Yes. As far as...
myself.
A lot of evidence on this particular issue.
On this point.
So,
yes, this is on the effect on the child of the potential risk of the risk of suicide.
In fact, actually, it would be the response of the child.
Yes.
Because the effect, we have the effect, that is of extreme psychological harm. And it's the response of the child to that. And I'm not certain there's a lot of evidence about that.
I think the evidence before the court on that, my Lord, is the second affidavit of the child. And if I can perhaps go to paragraph 15 of that, first of all.
So it's page, what's right?
And that is at page 145 of the bundle. And there, the child discusses the mental health issues that his mother has experienced with reference to depression, having been suffered for years.
I don't think it's that one. It's 15, isn't it?
15. I'm sorry, my Lord. I think...
you did say 15.
Yes.
Oh, I beg your pardon.
So at paragraph 15, there is the reference to the mother having suffered for depression for years, not something that's happened recently. I don't think my mum saw anyone about her depression, but she did have medication for it. Not aware of her having received any new medication more recently. I know that my mum tried to commit suicide before she met my dad. This is something I've been aware of for a couple of years now. So there is a long-standing history here which the child is well aware of. And then it's at paragraph 26, as has already been discussed today, that the child gives some evidence in relation to his mother's mental health. And at the end of that paragraph states, if I went back to the USA and my mum's mental health declined and she tried to take an overdose again, I would feel sad, but I don't think I would blame myself because I haven't asked her to stay in Scotland or to do that.
The whole paragraph, you read it from the start, is predicated upon mum still being alive. I would be able to call and text her. I think I'd be able to come back to see her, maybe 2 to 3 times a year. If she's killed herself, he won't be able to.
He won't.
And the paragraph doesn't deal with that situation.
He won't, my Lord, but the question is, if this child is not simply looking at a future where his mother is no longer there, this child is looking at a future where he hopes that she will be. Now, this is not something that is a certainty, and it is difficult
But that's the risk
it is a risk.
The judge is having to evaluate.
It is a risk.
And the child isn't confronting that risk.
The child is confronting that, my lady, in that he's not simply talking about mental health. He's also particularly anticipating an issue with her trying to take an overdose again. Now, this is not simply a deterioration in mental health that he's talking about. He is anticipating a suicide attempt within this
but he's not
paragraph.
anticipating a successful suicide attempt. The whole paragraph does not deal with a situation in which, because he has gone back to the US, his mother may kill herself, and he has to confront that. And paragraph 26 doesn't do that.
It doesn't, Lord, and I can't say that it does. What it does is anticipate a situation where his mother might take an overdose, and I say that is an anticipation and a discussion of the possibility of committing suicide, which is what is the factual situation here. It is the possibility of committing suicide. It's the risk, as Her Ladyship indicated. Now, in relation to the evidence in relation to this, there is a concern for those acting for the second appellant that the young person here is being asked to take too much of the burden on himself of his mother's health, and that is particularly in relation to his age. He, at the moment, is presently living in the UK for the next 10 months before he is able to take himself onto an aeroplane because of the possibility of his mother's mental health difficulty being exacerbated should he return to his country of habitual residence, the USA. Now, that is a very difficult position for a young person who is growing into his own adult identity. And this is a 15-year-old now who would, in any circumstances, wish to leave home at some point in the relatively near future. That might be whether to attend college or some other endeavour. This is a young man who wants to train as a pilot. The probability of this child leaving home in any case under his own steam in a short period of time is the very point which the Lord Ordinary makes at paragraph 87 of his opinion. And his age is crucial here. He has already voted with his feet to the extent that he is able to, in that he is no longer living with his mother by his choice. Now, he still has contact with his mother, and of course his little brother lives still with his mother. The report from Dr. Edward has been referred to by Mrs. Scott, and it is important to say that that was prepared on the basis that she did not meet the children and only had sight of the mother's affidavit. It was commissioned by the mother, and Dr. Edward is very careful to set out the limitations of her report within that report. As far as life for this child, whether it be in the USA or Scotland, is looking like, it was submitted for the child before the Inner House that it is valid in assessing intolerability to compare life for the child in Scotland with life in the USA. And the unfortunate position is that neither is in any way ideal. There are real issues for this child if he requires to stay in Scotland. He has an extremely difficult relationship with his maternal grandmother, with whom his mother lives. I've made reference to him already voting with his feet. And the Lord Ordinary was correct to identify the particular difficulty and the importance for this child at his age in moving to the Scottish educational system from the American system. In terms of maturity of the child, it is submitted for the respondent that no school reports were lodged in respect to the second appellant, but that is incorrect in that school reports were indeed lodged. They were before the Lord Ordinary in his assessment of the child's maturity. And it would be startling indeed if a 14-year-old child was held not to be mature enough for his view to be considered and taken into account.
My assessment is the age and maturity of the child, crucial factors. Also, when you're evaluating his wishes and feelings, you take into account whether or not he's got reasons for expressing those views. And he's articulated those reasons, and they're very, very valid reasons. What you don't do is, of course, compare on which is best, namely America or Scotland. What you do is you evaluate the genuineness of the views of the child, and he's explained why his views are genuine. And his age speaks for itself. So, I mean, I don't understand you to be saying, well, you know, it's better for him to go to the USA as opposed to remaining in Scotland. That's not the issue for the court. The issue is whether or not he's got genuine views and whether they've been taken into account. And so the comparator between the Scotland and the USA supports the genuineness and maturity of his views.
Yes,
it isn't a best interest decision at all. Right.
No, that's exactly my point,
yeah.
Lord. And finishing that point, the Inner House accepted that the child's solicitors and counsel would have been satisfied as to his capacity to instruct his legal team. And again, it would be odd indeed if he had that capacity, as is presumed from the age of 12 in Scotland, but was considered not to be mature enough for his views to be considered. In terms of taking the views, I do just mention the reference by Reunite in relation to the involvement of Kafkas, and I see that I have not noted the page number to take the court to. The point I make in short is that in Scotland, the practice in Hague Convention cases is for the views of the children to be taken by way of the appointment of a child welfare reporter, who will almost always be an experienced family law advocate or senior counsel who's aware of the nuances of the remit to take the child's views. And Leonard Jr. has given me the reference, it's page 16 of the submissions for Reunite at paragraph 38. There's a concern expressed in the written case for Reunite that taking the views of every child in Hague proceedings will cause delay because of delays with Kafkas reports. In Scotland, there is no such delay. Child welfare reporters will routinely report within 2 weeks or so when asked to do so. And the principle of the requirement to take the child's views and then to consider them and what weight to be attached to them cannot, in my submission, be subverted or disregarded due to delays which are being suffered at the moment within the English system. This is a child whose views are based on his own lived experience in Scotland and in the USA, but he's told by the Inner House that those views are irrelevant to his own future and where he lives. Now, the Lord Ordinary's approach to this matter, I say, was thorough in the circumstances of a Hague Convention case and is the correct and appropriate approach. And the passage from the Lord Ordinary at paragraph 86 of his opinion at page 130 of the bundle has already been referred to. The child is aware of the fragility of his mother's health and better able than B to take an informed view as to whether he would find it intolerable to be living on the other side of the Atlantic from her in circumstances about which he's reasonably well informed. Now, that passage does indicate that the Lord Ordinary approaches this from the perspective of the child, as he is required to do. I do just highlight that the respondent indicates at paragraph 40 of her written case, the last two sentences at page 38 of the bundle, that the Lord Ordinary fell into error in his lack of scrutiny of the child's true tolerance, and that the inner house were correct to allow the appeal. And I just make the point that that was not the basis on which the inner house allowed the appeal. The appeal was allowed on the basis that the Lord Ordinary should have had no regard to the views of the child at all. If I can address the issue of influence or manipulation, and that is raised at paragraph 41 of the respondent's written case at page 38 of the bundle. Now, we've already gone to the passage in the Lord Ordinary's decision where he acknowledges that the respondent's claim in this respect was to an extent supported by her evidence and that of her supporting witnesses. But what he goes on to say at paragraph 45 is that that is denied by the petitioner and by H himself. Now, the Lord Ordinary heard competing evidence in relation to manipulation and influence at first instance. It should be said that substantial...
So when you say he heard, you don't mean he heard. He heard?
He heard...
He had affidavit evidence.
He had affidavit, yes.
Sorry, he didn't.
I'm sorry, and I use that perhaps colloquially. He had evidence before him, but he also heard substantial oral submissions which were made on the child's behalf in answer to the first respondent's claim of influence. And
could I ask you, just as a matter of trying to orientate my mind around it, my understanding is it's appropriate to take the child's views, and I would add evidence, in relation to Article 13, Article 12, without any reservation about what the issue is, subject only to it being appropriate to do so.
Yes.
So you take into account the best interests of the child. If the child is going to be harmed by it, you take into account the child's best interest, and you say, in these circumstances, we don't need to ask the child for the views about this particular topic. So best interests come into play in the decision as to whether or not to obtain the child's views. Why doesn't best interest also come into play when you are protecting a child from manipulation? That is, if you ask the child to express a view, surely the court has also reads across to the best interests of the child to prevent that child from being manipulated. So doesn't the court have to form a view about that if the court is undertaking a role protecting the child's best interests?
I think, my Lord, only if evidence is available to the court to allow them to do that. And in the specific circumstances of this case, the Lord Ordinary heard competing evidence in relation to influence, particularly the evidence of the young person in this case was that the attempts to influence had come, in fact, from his mother's family, and in particular from his maternal grandmother, rather than from the father, and he denied pressure being exerted on him by his father, and of course as a party to these proceedings, but also as a child who has been growing up within the family prior to these issues. The child has been aware of the positions for each party. So, in a scenario where the Lord Ordinary heard competing evidence regarding influence, his decision to leave that factor out of account in the final analysis makes sense in those circumstances. He did not make a finding because he did not feel able to make a finding. And he was the fact-finding judge who read affidavits, heard submissions. That was his decision on the basis of the hearing at first instance.
There must be some situations where the affidavit evidence just doesn't permit you to reach a finding, and you don't have the option of hearing the witnesses give evidence and then being challenged, cross-examination, which enables you to form your view. You know, in some rare cases, maybe there will be external materials, evidence which one can refer to in documentary form or other, or other affidavits, which you do accept as credible and reliable, which would assist you in favouring an account given in one side set of affidavits. But it plainly doesn't appear to have been the situation.
Exactly, my Lord.
So what else is the Lord Ordinary to do?
In those circumstances, my Lord, yes.
So if the test is that you only and I'm going back to your quotation, I think, of Baroness Hale from Re-S, which I think you took us to earlier.
It was in Re-E I'd mentioned, my Lord, but Mrs. Scott.
This was the one about not interfering with.
It's Lord Wilson in Re-S.
Ah, yes.
Okay.
Yes.
Sorry, I'm just making sure I get it right. It's Baroness. You referred us to Re-S.
Yes.
And in Re-S, there's a reference to Re-J and what Baroness Hale said in Re-J. So I think is it Lord Wilson referring to Baroness Hale, right? So anyway, is this right? If that is the test for interference by an appellate court with a decision by a first instance judge, I think your submission is that on the facts of this case, it was not irrational or not an error of law for the outer house to decline to make a finding on manipulation. So we just should accept it.
Yes, my Lord.
That is, it's not a fault in his judgment.
Yes, my Lord.
Because this was not a case where he was able to,
exactly,
for whatever reason, and that wouldn't be a reason to interfere with his decision.
Yes.
The more pertinent point, I think, that has been put to you a number of times, just to make it explicit, is that the finding in relation to the appreciation of the views of the child, if the mother was actually to succeed in suicide, is something that the outhouse did not reach a view on and should have done.
And I think, my Lord, perhaps all I can say in response to that is the reference to what the Lord Ordinary actually said, which I'd mentioned at paragraph 86 of his position in relation to the child's state of awareness and view as to whether he would find it intolerable to be living on the other side of the Atlantic from his mother in those circumstances. And that is the passage within his the Lord Ordinary's judgment which deals with that issue. If I can turn briefly to Article 12, and and the court has the position for the second appellant in the written case. I won't repeat that argument. I would say that at the end of paragraph 51 of the respondent's written case, which is at page 41 of the bundle, it's stated for the respondent that it can't be said that the views have been disregarded or not taken seriously merely because the views of the child have not prevailed. What can be said as a matter of certainty is that the child's views have been disregarded because the Inner House specifically state that that is what they have done, that the child's views are irrelevant. If I can go to the respondent's argument from paragraphs 59 onwards of her written case, and that's at page 44 of the bundle, that is that the child's best interests have primacy over the requirements of Article 12, and I say that that is overstated. The respondent argues at paragraphs 63 and 65 that Article 12 rights can be limited or curtailed, where Article 3 so requires in the best interests of the child. The position for the second appellant is that Article 12 rights cannot be curtailed or limited by Article 3. Article 12 sets out the right of the child to be heard and for his views to be given due weight, and it's when due weight is considered that the best interests of the child will be relevant, and it's in this way that Article 3 and Article 12 rights are balanced. Article 12 rights can't be limited because the check and balance regarding best interests is already built in to Article 12 in the requirement to give the views due weight. If I can deal again briefly, given time, with the ECHR point, again that is set out in the written case. Article 8 includes procedural as well as substantive rights. There are positive procedural obligations inherent in the right to respect for family and private life, and that can be seen from the third section decision of the Strasbourg Court of MP and others against Greece at page 684 of the bundle. And in that case, of course, the Greek courts had ordered the return of 2 children to the USA without their views having been heard at any stage.
Sorry, what was the page number?
That is at page 684 of the bundle. The conclusion of the court, and I'll just go straight to that, is at paragraph 104, and that is at page 705 of the bundle. The court considers that the domestic courts were not in a position to determine on an informed basis whether there was a risk within the meaning of Article 13b of the Hague Convention, and that the decision-making process under domestic law therefore failed to satisfy the procedural requirements inherent in Article 8 of the Convention.
I'm not sure. I'm not sure just how much you can make of this. I mean, if you look at 102, which is where the reasoning is, 104 states the conclusion. 102, the court notes that the applicants contend that a hearing of the children was essential. It then notes that the applicant's return was likely to entail considerable changes in their lives. Accordingly, the court considers that having regard to the specific circumstances of the present case, namely on the one hand conflicting decisions by the domestic courts concerning the return, and on the other the radical change in their living conditions that such a return would have entailed, the domestic courts should have endeavoured, by virtue of their obligation to act in the best interest of the children, to consider whether it would be appropriate to hear the children. So it's a very cautious decision.
It is cautious there, my lord, but when we look at paragraph 104, that is, I think, less cautious in the statement of the conclusion of the court in this.
Well, does it really go? I mean, if you go back again to to 102, it concludes by saying that they did not examine of their own motion whether it was appropriate to hear the children. Okay? Pursuantly above 103, pursuantly above, the court concludes the domestic courts did not use all the means at their disposal to exclude any serious risk. In conclusion, the court considers that domestic courts were not in a position to determine on an informed basis. So that's 104 is simply, expressing drawing out the implications of 102 and 103, I think.
Yes, Mord, I would simply take the court to the sentence, I think, at the bottom of page 705, where it's stated, and that's paragraph 102, the court therefore finds that domestic courts assessed the situation without considering whether it was appropriate to obtain the children's views, yes, which was a key element.
But it's not saying it's a key element in every case. It was saying that in the specific circumstances of this case, which it then details, they should have looked more carefully at this.
Yes, and I think it is the argument for the respondent is that the hearing of the child, the respondent seeks to distinguish the Greek case from the circumstance of the present case. And there is a difference. The present case, that the child was heard by the court, with his views being provided by way of representation, which did not happen in the Greek case. I would say that where a child is technically heard by the court, but his views are held to be irrelevant, that child can't be considered to have been properly heard by the court in the true meaning of the word.
Yes, well, there's little point, one might think, in hearing the child and then ignoring
exactly
what is said.
The argument is within the written case. In relation to the exercise of discretion, and that is my last point. Again, the second appellant's written case deals with his position on that, and that is at paragraph 26 to 49. The respondent submits at paragraph 45, which is at page 39 of the bundle, that there's a consistent seam of authority that the exercise of discretion after the establishment of an Article 13b defence is established is inconceivable. That is not accepted for the second appellant. Looking at the written cases lodged by for the interveners, there appears to be a clear divergence of view between Reunite and the International Centre of Family Law Policy and Practice as to whether there is an extant exercise of discretion available to the court after an Article 13b defence is established. I say that following upon Baroness Hale's obiter remarks in INRI D and INRI M, where she discussed the inconceivability of returning a child once grave risk was established, there's a consistent line of English authority where those remarks have been interpreted as meaning that it will be very unusual circumstances where return is ordered after the establishment of a grave risk defence, but that the discretion to return remains. And that line of authority is set out in detail at paragraphs 34 to 40 of the second appellant's written case, starting at page 61 of the bundle, with reference to 5 separate English cases, and the developed argument is set out on that within the written case. But I would specifically take the court to the Scottish authority of AD against SD, and that is at page 221 of the bundle. The decision in that case also accords with that interpretation in that it found that return would be inconceivable on the facts of the case. Now, the decision in AD against SD is a decision of an extra division of the Inner House delivered by Lady Wise. It's clear from paragraph 30 at page 229 of the bundle that the risks identified in this case were of physical injury to the mother in the presence of the children, sexual assaults and numerous verbal assaults. And at paragraph 39, page 231, it's identified that there was ample material from which it could be concluded that there was a grave risk to the mother and the children, that they would be exposed to uncontrolled and irrational behaviour if they were returned to close proximity of the father, with the risk of consequent harm being extremely serious. And there were concerns as to the efficacy of protective orders by the Illinois court. Now, against this extreme background of allegations of physical and sexual assault, some undisputed evidence of that behaviour before the court, Lady Wise sets out at paragraph 41, which is at page 232, that in all the circumstances and having regard to the extensive material available, we are satisfied that SD has established a grave risk defence under Article 13b of the 1980 Hague Convention. Despite being so satisfied, we have a discretion to decide to return the children. However, it would be inconceivable that a return would be ordered given the material before us, and we shall refuse so to order. Cases of this sort are inevitably very fact-specific, and this court is conscious, as was the Lord Ordinary, that the primary obligation, where children have been retained outside their habitual residence in breach of the other parent's right of custody, is to return them swiftly. In the particularly unusual circumstances of this case, we have concluded that to do so would give rise to an unacceptable risk. I say the exercise carried out by the Inner House in this case of AD against SD is consistent with that English line of authority in that the court considered the material before it in determining whether the court should exercise its discretion to return after the establishment of a defence under Article 13b. And it's unsurprising that the court refused to exercise that discretion in what Lady Wise describes as the particularly unusual circumstances of that case. In the present case, the Inner House took the view that discretion could not be exercised as a blanket rule, which is at odds with the English line of authority following In Re D and the Scottish case of AD against SD. For all those reasons and those set out in the written case, the court is invited to allow the appeal to recall the order made by the Inner House on the 10th of February 2026 insofar as it relates to the second appellant, and to reinstate the decision of the Lord Ordinary. And unless I can assist your Lordships and your Ladyship further, those are the submissions for the second appellant.
Thank you very much indeed, Ms. Shewan. And we'll hear Ms. Clark after the short adjournment. We'll adjourn now and resume at 2 o'clock.